Right, well, there's a lot to unpack there. Let's discuss this further now with legal analyst Mpumelelo Zikalala. Mpumelelo, that conflict of interest cited by the suspended public protector, essentially arguing that the state attorney not only receives instruction from the Office of the Public Protector, but also is instructing Section 194 evidence leaders. Do you see a conflict there? Is there any weight to the claims that Mkhwebane is making in this regard?
Definitely, there's a clear conflict. Good morning to you and also to your listeners. There's a clear conflict. Just go back to the recent case or recent judgment which was issued at the Western Cape Division. The first respondent was represented by the Office of the State Attorney, the first respondent being the chairperson of the committee. Now, in what world do you have one party representing the applicant and the other party representing the respondent? It doesn't work in that particular manner. A person who's going to represent you and make sure that they're able to protect and promote your legal interest must be able to provide you with the confidence that their fiduciary duties are only directed, or their allegiance is only directed to you, because there's going to be confidential information which is going to be shared between the parties. There's going to be litigation strategies which are going to be discussed between the parties. Now, how am I giving an assurance as a public protector that at the end of the day, whatever that we are discussing, because it goes back to the same office, it's received within the same email domain, they use probably the same photocopying machines, is not going to be shared with the other party. As perfectly stated by the person who was speaking earlier, if the public protector were to go to court today, it then would mean that the Office of the State Attorney would appear twice, both within the applicant's part and also within the respondent's part. It does not work in that particular manner. All you need to do, go back to what the Constitutional Court has said. It said, we realize the importance of having a public protector who is going to be legally represented. Let her have her own legal representation of her choice, so that she is able to defend herself optimally or in a manner in which she sees fit.
Right. And what do we make of, the termination of Hope Chane as legal services? Because once the Sianecho attorneys essentially terminated their relationship with the suspended public protector, Hope Chane was Mkhwebane's attorney of choice. That individual has subsequently fallen ill. We haven't essentially verified that, but that is according to Parliament Section 194 inquiry, that this individual has fallen ill and the state attorney has as such been forced to terminate that relationship. What sort of legal options does that leave the suspended public protector?
She still has the benefit of using her own choice of legal representation. So if I don't have the person who's supposed to represent me, all I can go to the chairperson and say to them, please give me a few minutes or give me a few days, so that I can be able to go and discuss and find another legal representation which is going to defend me. I cannot go within these particular proceedings without being defended. If my attorney of choice is fallen ill, it's an unfortunate event. Some things and circumstances which are beyond our control. So allow me that reprieve to go and look for someone else so that they can come back and continue with the job that there is. I think what they're all trying to do is trying to defend the indefendable. They're trying to save something which can't be saved in this instance. You are not going to save any money by saying that the Office of the State Attorney must then come in. The process here, the intention is not to save money, unfortunately, is to make sure that if you go into that particular committee and that committee takes a decision, you have the confidence of saying that I poured all that I could, I was legally represented in a proper manner by the attorneys or legal representation of my choice. I was able to state all the points that I needed to state in instances where I was disgruntled, I was able to go to court and be able to defend my legal interest. So I accept the decision that is there. It is not only the process of saying the merits of the matter or the substantiveness of the case must be correct. Also procedurally, it's what the court is going to look at a later stage if this matter were to go to court. So do not mess up the procedural part of these particular proceedings, because it may turn these proceedings, which maybe on the substantive part they were correct, to being something which the court is going to say, we are not going to accept this, we are going to rule it as being unlawful and set aside whatever findings that have been found by the committee.
It's interesting, Mpumelelo, that in the face of that Constitutional Court ruling, we still have the committee chairperson essentially suggesting that committee members put all questions in writing as they relate to the charges being faced by Mkhwebane Is that a viable option, given the fact that the Apex Court was quite adamant that the public protector needs to be legally represented? She herself is saying that she can't answer to those questions without legal representation being present.
Let's separate it into two parts. The first one is that the applicants, which is the legal reps representing the committee, would then have to submit theirs first, and then the public protector would answer based on what she's received. She'll be handicapped if she does it on her own without the benefit of having a legal reps next to her. The purpose of having them there is solely there to advise her, to go and research, come back, and formulate legal arguments which are going to assist her at the end of the day. So if you adopt that option, you are already breaking that cardinal rule which was issued by the Constitutional Court. Secondly, it would depend on what part of the proceedings are we at. Are we only limiting to final submissions which are not going to be subject to cross-examination? If there are any instances in which we must raise objections verbatim or viva voce, where am I going to do that if I'm only restricted to writing this submission at the end of the day? What must be important is this. Yes, you want to finish the work as soon as possible, but do not compromise the integrity of the work by wanting to short-circuit it as a few things. The purpose here is not to make sure that the work is finished on time, but is to make sure that whatever which is finished at whatever point in time, the procedural and substantive fairness and all the other things that go with making sure that you're able to receive justice are done correctly. If you do not do that, everything that you do is going to cause you problems, and that's where the problems are going to lie at a later stage. I will again come back to submission that I made a while ago. The problem that we have with this committee, it is formulated in a tool that is not going to assist Parliament into finding the truth. You can't have those so many presiding officers and a chairperson who at some time would seem as if is not playing in a fair manner, and I'm saying that in inverted commas, allowing them to take a decision which is very important. What ought to have done is to say, these are the rules in which we are going to follow as a committee. We are going to try and stick so much to quasi-judicial processes so that we can be able to deal with the truth and the accuracy of whatever evidence that comes in here. We'll try to stick with what is happening within the courts so that we do not derail from what they usually do on a daily basis. Their methods have been tried and tested. In instances where biasness is alleged, there's a clear way of how to deal with them. In instances where evidence is supposed not to be accepted, there's a clear way of dealing with it. In instances where there are delays, there are clear ways in terms of dealing with it. We are not going to invent a new way, which is what they are doing here.
All right, Mpumelelo, thank you so much. We'll leave our conversation there. Thank you so much for your insights. That was legal analyst Mpumelelo Zikalala.